All right, well, let's go ahead and get started. Again, apologies for the couple-minute delay. Just wanted to introduce you and welcome you to the Building Telehealth with the CFR Part 2 and HIPAA 42 CFR, and make sure that you are in the right webinar. And so we will get started. My name is Christina Clayton, and I'm very grateful to be with you all today. I'm a clinical social worker and the program manager of the Northwest Mental Health Technology Transfer Center. So we're hosting this along with our partners, the Behavioral Health Institute and their Training, Workforce, and Policy Innovation Center, as well as our presenters, which is actually a panel, and our panelists. We appreciate that the capacity to provide effective telehealth treatment has really become an urgent issue in the context of COVID-19. We're very excited to have our subjects today and presenters. This is the 7th webinar in our 8-part series that aims to support community-based behavioral health providers in Washington and their implementation of telehealth services. We will share via the chat that you can access all prior sessions, and so you can view recordings, see the slides, and Q&A sheets when those are provided. We have structured these sessions so ample time is dedicated to Q&A and discussion. But first, a little introduction about the Northwest MHTTC. The MHTTC network is a nationwide network funded in late 2018 that is supported by the Substance Abuse and Mental Health Services Administration, otherwise known as SAMHSA. Its purpose is to disseminate and implement evidence-based practices for mental health disorders into the behavioral health workforce. Our Northwest MHTTC is based at the University of Washington in the Department of Psychiatry and Behavioral Sciences. We provide training and technical assistance to evidence-based practices in Region 10, which includes Alaska, Idaho, Oregon, and Washington. We also promote our resources, online trainings, and other opportunities nationwide. Broadly, our goals are listed here. You can read more about them on our website, but essentially ensuring availability and delivery of free, publicly available training, heightening the awareness, knowledge, and skills of the workforce, accelerating adoption of EBPs, as well as fostering alliances amongst our network. Next, we'd like to talk about language. It is our intention always to be mindful of using language that promotes recovery and culturally appropriate terminology. We encourage everyone to use and champion person-first language, which emphasizes the individual, not the condition or the disability or diagnosis.
Good afternoon, everybody. My name is Melody McKee. I'm the Program Director for the BHI's Training, Workforce, and Policy Innovation Center. Happy to be here today in partnership with Northwest MHTTC and our wonderful presenters who we'll be introducing shortly. This is session 7 of an 8-session series that we're doing in partnership with Northwest MHTTC, and we will be rolling out some additional trainings following this series as well. So check out our website for more information on that. Next, okay, so we have a group of presenters today from the Center of Excellence, and we're going to introduce them shortly, and then our regular panelists that we've had the entire time we've been doing this series. In addition, we do have Gail Krieger from the Healthcare Authority to help answer Washington-specific questions. So you have a glimpse of who we are, and we'd like to hear a little bit about who you are and where you're coming from today, what type of provider you are. You're going to see a poll pop up on your screen that asks you to tell us who you are: a prescribing provider, nurse or other medical worker, behavioral health clinician, therapist, case manager, outreach worker, administrator, tribal behavioral health or tribal health organization, education, school or school-based organization, clinical supervisor. So I see everybody's getting to the poll. We've got a large group of behavioral health clinicians and therapists today, along with some clinical supervisors, administrators, and some tribal participation as well. I'm going to introduce now Cara Tal from the University of Washington, who will talk about our presenters.
Thanks, Melody. I'm just going to do a quick introduction and just sort of reiterate what Melody said, that we have Gail Krieger, who is our contact at the Washington State Healthcare Authority. You may remember her. She did a presentation about billing and reimbursement a couple of weeks ago on this series, and she is our go-to guru about anything related to telehealth in the state of Washington, especially related to policies and reimbursement. And then we have a team of folks coming to us from the Legal Action Center Center of Excellence for Protected Health Information, and they will be discussing all kinds of policy issues and changes related to FERPA, HIPAA, and 42 CFR Part 2 today. And I'm just going to turn it over to them so that they can tell us a little bit more about themselves and their center.
Good afternoon, everyone, and thanks for joining us for our presentation, Supporting Washington State Behavioral Health Providers to Optimize Telehealth in Response to COVID-19. My name is Michael, and I'm the Project Director for the Center of Excellence for Protected Health Information, also known as the COE-PHI. We hope that you and your loved ones are all doing well and staying safe. We want to thank you for inviting us to present today and be a part of this important learning series. Before jumping into today's presentation, we wanted to just take a moment to introduce the Center of Excellence as well as today's presenters. So COE-PHI is funded by SAMHSA to assist people and organizations in understanding and applying current federal privacy laws and regulations on the job specific to their task and role, and also to assist patients and families in knowing what their rights are when seeking and receiving treatment. Our presenters today are Christine Kuiken, she's an attorney and the Health Privacy Associate for the COE-PHI, Caroline Waterman, Substance Use Disorder Lead for COE-PHI, Sally Friedman, also an attorney and the Senior Health Privacy Training and TA Director for the COE-PHI. And again, I'm Michael, I'm the Project Director. Next slide, please. So our presentation objectives today are to identify basic requirements of HIPAA and 42 CFR Part 2, also known as Part 2, to explore recent changes to the federal privacy laws outlined within the CARES Act, to explore privacy law application to remote care provision in accordance with recently released OCR and SAMHSA guidance, and to describe how to access the COE's resource library and technical assistance services. At this time, I'll turn things over to my colleague, Christine. Thank you.
Thank you so much to Michael and to everyone in Washington. It's been great getting to know all of you. In the next slide. Okay, so we're going to start with a little level setting about the federal health privacy laws. I have been told that many or most of you have some understanding of HIPAA and Part 2, so we're just going to do a quick overview to make sure we're all on the same page. So HIPAA, as I am sure many of you are aware, is the federal health privacy law that protects the privacy and security of general health information, and it applies to covered entities, so healthcare providers, health plans, health clearinghouses, and their contractors, also known as business associates. And the purpose is to protect health data and confidentiality. And this is really the foundational law. So many states, possibly Washington, I actually have no idea, but probably may have some additional health privacy laws and regulations, but the federal law is sort of the foundation and the floor. And it does allow disclosures of some health information for treatment, payment, and healthcare operations without patient authorization or consent. And so Part 2 is the much more narrow and specific federal health privacy law that is specifically for substance use disorder patient records from federally assisted Part 2 programs. So if some of you are not very aware of Part 2, that may be because it doesn't apply to everyone who provides substance use disorder services. It's a specific subset of providers. The Center of Excellence has a lot of great resources to let folks know whether they do or do not have to comply with Part 2, and we can also provide TA on that. So Part 2 protects the privacy and security of records that identify individuals as seeking or receiving substance use disorder treatment services. And really the purpose of that is to encourage people to enter or remain in treatment by guaranteeing confidentiality. This is very sensitive information, obviously, and that's really the purpose of Part 2. And a really big distinction between Part 2 and HIPAA is that the Part 2 protections follow the information in Part 2. So first of all, you need written patient consent to share information for most purposes, except for a couple of exceptions, and that information continues to be protected, and Part 2 applies to subsequent redisclosures. Next slide. Okay, so now that we have a baseline, we'll talk a little bit about changes in the CARES Act, which was the big package of legislation passed by Congress in response to COVID-19 back in March. And it did include, it snuck in some changes to Part 2. So it included some changes to the statute that underlies Part 2. There's the 42 CFR Part 2 are the regulations, and then there's the underlying statute. So Congress amended the statute, and SAMHSA will be issuing new regulations to implement and clarify the changes that were included in the CARES Act. But it's really important to note that these changes will not be in effect until March of 2021. So Part 2, as you know it, is still in effect, and you should follow it until that time. Okay, so we just have a couple of highlights here. So initial written patient consent will still be required to disclose Part 2 protected substance use disorder records, but the big change is that after initial consent, some redisclosures will be permitted. So I just said earlier that Part 2 follows the information and continues to protect that information, but that is where the big change is coming as under the CARES Act. So now for treatment, payment, and healthcare operations, by information disclosed by covered entities and their business associates and Part 2 programs, you will not need written patient consent to disclose that information. However, patients will still have the right to revoke that initial consent. And most likely, the new regulations that will come out from SAMHSA will explain how all of that will work. Okay, next slide, please. Okay, so I just wanted to do a little poll to see if I explained that well and if what you all are thinking. So true or false, the CARES Act repealed 42 CFR Part 2. So the poll launched. The vast majority of you said false. Okay, yes, the answer is false. While the CARES Act makes changes to the substance use disorder privacy law, and there will be future changes to the regulations, it did not repeal the law entirely. So Part 2 still exists and will still continue to exist, but the protections under Part 2 will change, but it will not be effective until March of 2021. Okay, so now we're going to talk a little bit about the shift to telehealth and privacy, which was happening slowly before the COVID-19 pandemic and is now sort of happened all at once. And so there are some privacy considerations. So I want to do a quick poll to hear about what you all are using to deliver telehealth services in this new environment. The answers, and you can select more than one on this, but we're interested if you're using HIPAA compliant video communications, other video communications, text messaging, phone calls, or other methods. Okay, so it looks like a lot of people are using the HIPAA compliant video communications, but also using some of other popular video communications. Nobody said text messaging, which is interesting. I usually hear a lot of people asking about text messaging and phone calls. Okay, great. So let's close the poll and move on to our next slide. So there are a lot of privacy considerations for telehealth. We get a lot of questions. How do the privacy laws apply? Do they apply at all? And how to protect privacy and security both at your location, the provider's location, whether you're at home or in a clinical setting, and also at the patient's location, whether they're at home or somewhere else or in a clinical setting. So again, this is just a very quick refresher. We have HIPAA and Part 2. These are the federal health privacy laws. And you should know neither of these laws include specific provisions for telehealth, and it's all a matter of applying what they already say to your telehealth services. So OCR, which is the Office of Civil Rights, is part of the Health and Human Services Administration. They did release some guidance in response to COVID-19 to facilitate the use of telehealth, and they said that they will not be enforcing penalties for HIPAA violations arising out of good faith use of telehealth. So, I saw in that poll, many folks said that they are using HIPAA compliant video services, but right now there will not be penalties if providers use popular video chats like Apple FaceTime or Facebook Messenger, Google Hangouts, even without a business associate agreement with the service. And it doesn't matter if the telehealth service is related to diagnosis or treatment of COVID-19 or if it is for something else. So this applies broadly even to substance use disorder services, mental health, or primary care, anything. But it's still really best practice to use those secure HIPAA compliant services and have a BAA in place. The reason being, this will end and you want to have all that secure service all set up if possible. And also, if there is some sort of data breach and information is released, you can't really get that back in. Once information is out there, it's out there. And so protecting privacy at the source is really the best practice. Okay, next slide. So there was also guidance from SAMHSA regarding Part 2 to facilitate telehealth. So we'll discuss that now. So I'm going to do a quick review for those of you who may not be as familiar with Part 2, or just a reminder that Part 2 generally requires written patient consent to share protected information, but there are some exceptions, and one exception is for medical emergencies. So Part 2 already does permit disclosures without written consent, and actually without consent at all, to medical personnel in order to treat a bona fide medical emergency. And under this exception, information may be redisclosed for treatment purposes, and you cannot use this provision to override a patient's objection to a disclosure. So this is not to override when a patient says, no, I don't want my information shared. And it's really important always that disclosures made under this medical emergency exception are documented in the patient's file. So that's the review, that's the existing exception. And SAMHSA's guidance said that providers have discretion to determine whether a medical emergency exists. They really emphasized this during COVID-19. And really what they're saying is that the medical emergency could be that an individual needs substance use disorder treatment and could not otherwise obtain that treatment if they can't get a consent form signed. You can use this medical emergency exception to make sure that person can get treatment even if the consent can't be obtained. So that's the issue here, because treatment providers are closed or because of social distancing. And so that's what they've said, but they have not otherwise waived any other requirements of Part 2. So again, these are the really key points for SAMHSA's guidance. SAMHSA has not eliminated Part 2's requirements for written consent to share information. It is still required for other purposes, including to share information with a payer for billing purposes. But as before, no consent is required in a medical emergency, and SAMHSA has really given providers the opportunity to use more discretion to determine that a medical emergency exists in order to treat a substance use disorder. And e-signatures and I guess this got cut off. E-signatures and photocopied signatures are permissible. It should definitely say permissible there. So Part 2 does not require a wet in-person signature, and there are ways to obtain signatures on a consent form in other creative ways, including e-signature like DocuSign or Adobe Signature or photocopies. So the Center of Excellence has created several resources to help providers think about protecting privacy, and also to help their patients or clients to protect their own privacy at home or in whatever setting they are in. These are images of our resources. They're available on our website, coephi.org. Both of these resources, I think, are really helpful. They include reminders about making sure any devices used are password protected, and to use a password protected Wi-Fi and use encrypted communications apps, that are available widely. And if you can't use an encrypted app, there's guidelines about making sure privacy settings are as strict as possible. And there's also some advice about how to make sure your surroundings and your patient's surroundings are safe from roommates, family, friends. I know we're all in tight spaces right now. And we also have a video that I think is really helpful for remembering how to keep patients' information private. So we're going to launch that now.
This is John. John needs to see his provider for treatment for a substance use disorder. However, due to COVID-19, he can't leave his apartment. His provider's office reached out and set up a date and time for John to meet with his provider from his home. John is relieved, but he's also nervous. His roommates don't know he's receiving treatment, and he wants to keep it that way. So, how can he keep his conversation with his provider and his personal health information protected during a telehealth visit? John has a few options that includes these 3 key strategies. First, he can protect his communications. John should work with his provider to select the best way to receive services. He should also make sure that the privacy settings on his device are adjusted for a telehealth visit, including turning on encryption and turning location services off. If John is borrowing a device from one of his roommates, he needs to ask his provider to not send confidential treatment information to the device. John should also delete the conversation history from the borrowed device after the visit. Secondly, he should prepare his surroundings. If possible, John should try to find a private space to talk to his provider, and if he can't find a private space, use headphones so that no one can overhear their conversation. He can also establish a safe word with his provider at the beginning of the conversation to alert the provider in case someone enters the private space. 3. John should protect the device. He should make sure his device is password protected and that he is not using a public Wi-Fi connection. He should also consider changing his device password if others know it, in case treatment information is sent to the device. By protecting his communications, preparing his surroundings, and protecting his device, John can ensure that his personal health information is protected while getting the services he needs through a telehealth visit.
I think we are. Hi, yeah, this is Sally Friedman. I'm going to read off, and there's so far maybe 2 questions that come in. Somebody asked, is there any flexibility for obtaining consent verbally for clients who don't have the ability to submit an electronic consent form? For example, people experiencing homelessness. So I'm going to take a crack at this, and then Christine can chime in. We're covering. Christine's really covered the substance use disorder confidentiality regulation, so I'm not sure what this is referring to, but if it's under that, there is no possibility for verbal consent. So for disclosure of information, unless it's the medical emergency context, which Christine explained that under the medical emergency exception, SAMHSA has said that you can interpret that exception for user discretion, and so use that exception for communications with other healthcare providers. So I guess the question is, what would you be obtaining the consent for in this instance? Who do you need to disclose the information to? If you need to disclose it to another medical provider for treatment purposes, then it can be done without the consent under the medical emergency exception. But if you need to disclose the information to somebody else, then you do need, that does require consent, then no, verbal consent would not be okay, but there are, potentially different ways to try and get electronic consent, whether it's through DocuSign, or a scanned copy if there's time or ability to mail someone a consent form and then they sign it and they could just show it to you through video, or they can take a photo of it and send it to you. I mean, again, this all assumes a certain level of technology that somebody has. Christine, did I leave out any other options?
No, I think that was fantastic. I mean, sometimes it's helpful to hear what other providers are doing, because I've done a few webinars and had conversations, and someone always has like a really great solution. I will say though that I just want to make sure that we, Sally just said this really well, but we are talking about consent to disclose information, but a consent to treatment, an informed consent to treatment, or a consent to provide the telehealth service is different. And I may ask Gail about whether that is allowed to be done verbally in Washington, but we are really just talking about consent to disclose protected health information, which is a different animal.
And the person just, I guess, wrote a follow-up question about that and asked whether this medical emergency exception that we talked about would permit redisclosure via the collective platform. I don't know what the collective platform means. So
I don't either.
Yeah, so we may need some clarification about that. So meanwhile, I'm going to go to another question that came in earlier. And that is about, this is actually not the substance use disorder context. This is someone who's working in, actually SUDP, people are using acronyms. I don't know what that means either. SUDP, someone who's a SUDP working in prevention, has a youth who has, engaged in self-harm within the month, and needs a referral for a mental health referral. Would that constitute a medical emergency so that you wouldn't need consent? Again, if it's about, if you're covered by 42 CFR Part 2, and you need to do a referral because someone has engaged in self-harm, and then you would be able to deem that a medical emergency, and you would not need consent. So I hope that answers that question. Okay, now sorry, I'm flipping back and forth. The person who asked the question about oral consent has clarified that the collective is part of the EDIE/pre-managed system that King County and Washington State is implementing for care coordination. So if the question is, can you redisclose information, I guess, under the medical emergency exception beyond the disclosure to medical personnel, can that information be redisclosed to others, like caregivers and people doing care coordination, without consent? I would say the answer is no. So the medical emergency exception only allows disclosure of information to medical personnel who need it to provide treatment to that individual. It doesn't allow, however, I should say, whether they can then redisclose it to the family, for example. Christine, you want to address that?
Can you repeat that?
So it's basically what this, actually it's a new person's writing that collective platform is a platform that hospitals and emergency departments use to notify caregivers, physical and behavioral, that their patients have gone to the hospital or the ED. It can also contain guidelines. I'm sorry, I was misreading that. It can also contain certain guidelines for ED personnel about treatment considerations. So yeah, it sounds like that's all within a medical sphere. So I think that all would be justified under the medical emergency exception, because it sounds like these are all medical personnel.
Right, and also if it's in the emergency room, it sounds like this is for an emergency room that may not actually be covered by Part 2. The information that would need to be disclosed depending on the emergency and the treatment information.
Right. This all assumes that the information is protected by Part 2. And as Christine said at the beginning, Part 2 doesn't cover all substance use disorder treatment and care. It only covers it when it's being provided by what's known as a Part 2 program. So emergency departments generally aren't Part 2 programs. So we're not going into depth, and that's like a whole nother topic. But it's important to first ask whether the information is even protected by Part 2 in the first instance. Someone wants to know which platforms are HIPAA compliant?
The OCR, in releasing the notice of enforcement discretion, they did release a list of platforms that are considered more HIPAA compliant. HIPAA compliant is sort of not really a technical term, but these are platforms that have stronger security protections and also have typically agreed to enter into business associate agreements with providers. So UpDocs, Zoom for healthcare, I think Doxy.me is one, Skype for business. And I can share that resource. I think it's linked in the slides, but we can share that resource. But OCR did release a list of platforms that they would consider more secure. And then the ones that they listed that would not typically meet those HIPAA privacy and security requirements are the sort of more popular communication apps that we mentioned, such as FaceTime or Messenger. These are things that, like for example, they may not have an end-to-end encryption, so the service provider, the vendor would have access to like the information in the chat or something. They use them for marketing purposes and whatever.
And can you, someone want to know what are some of the pros and cons of using a HIPAA compliant platform during COVID-19?
So I think I said this briefly, but it's really important to use the most secure platform possible. As I just said, some of the platforms listed, like the Google Hangouts and whatever, there's evidence that they can have access to a lot of the data and information that is exchanged and use it for marketing purposes, and they just don't have as strict security. So all that information can get out there. And while, there's two issues. One is that information could be out there and you can't get it back in. And the second thing is there may still be some state liability for using those platforms. It's unclear if entities in states are going to enforce HIPAA, even though OCR has announced that they will not be for these breaches.
It's also, just to add, it's just a good practice to get into because telehealth will exist and probably in a much more expanded way than it did, after COVID-19, if we can imagine that ever happening, but it will happen, and there will be more telehealth than there was prior. And so it would be good to kind of have your practices, the best possible practice. Of course, you want to also protect your clients' privacy to the best extent possible, but you also want to get in good habits for later when these kind of relaxed rules, some of them are going to probably change back, one might surmise.
Yeah, I would totally agree with that. I think it's definitely just good practice to think about the future, and really the guidance is if it's not possible, this is happening really quickly, your patients or clients may not be able to quickly switch to one of these services or may not have the technology, and that's really what this is for. Sounds like the CARES Act change to the statute aligns with HIPAA. Is that correct? I would say, and Sally, you may have more insight on this than I do, but I don't think it's definitely not exactly the same as HIPAA. I think that it has not gone quite so far, but the ability to redisclose information for treatment payment and healthcare operations does sound quite a bit more like HIPAA, although I think that there remains to be seen exactly what it'll look like in regulation as well.
Yeah,
I don't think it's exactly the same.
Well, I would add that, I mean, one of I think there are two substantial differences. One is that you still need consent for the original disclosure, and it's just the redisclosure that's allowed without consent for treatment payment and healthcare operations. So that's a major difference right there. Yeah, and then also redisclosure would not be allowed for various other purposes, whereas under HIPAA, redisclosure is generally allowed for everything. So I think those are the two main differences, and we'll see once the regulations come out, you know, what's really going to be the case.
Right. Yeah, I think that is the main difference. Someone also just asked a question about recording a telehealth session. So with regard to privacy, I can't speak clinically about the utility of doing that, but I think that it's not clear why you would record. You probably wouldn't record an in-person visit, so I'm not sure why you would record a telehealth visit. But in general, if you are recording it, it seems like it would be a challenge to keep that secure. And if it's on your computer, then people may have access to it. It's not that HIPAA specifically says don't do that, but that is a lot of sensitive information. If it's a counseling session, that would have heightened protections. If you could count the recording, I guess, as falling under the psychotherapy notes, which have heightened protections under HIPAA. I just think generally it would be a bad idea and could be very challenging to keep that secure.
So another question came in. I'm not sure if it came in before we talked about this, but for risk or liability purposes, do you encourage provider agencies to develop policies on consent protocols and confidential information exchange on non-HIPAA platforms during the pandemic? If so, do you have a resource to use as an example? Well, I would certainly say yes. During the pandemic and always, provider agencies should have policies about consent protocols. You know, consent is required now and has been and will be. So yes, and you know, with respect to protocols for info exchange on non-HIPAA compliant platforms, I mean, I guess I still would say yes, just in general, whether using HIPAA compliant platform or not, you still want to have policies in place for how you're going to get consent and, you know, when you, under what circumstances you will or will not exchange information. Someone else asked that they were told that Zoom is HIPAA compliant. Is that not accurate?
So there are actually two versions of Zoom. There's a Zoom for Healthcare, which is a separate product from Zoom. So it's different than what we're using now, and it could meet the requirements of HIPAA security and privacy, and but not the traditional Zoom platform like we're using right now. It's a different product. It's called Zoom for Healthcare.
Oh, here's a question that came in. How might a group help folks in supportive housing access telehealth services privately? So I assume that means like, how do you have a private space if you're in supportive housing? I think that's what the question is. I think I'm mindful of the video we just watched, right? About, you know, trying to find, you know, making an arrangement with whoever's kind of running the home to have a private space for, you know, the allotted time if possible. And if that's not possible, I don't know if there's an outdoor space that's possible.
Yeah, I think that, you know, I think that's a good question, and it really depends on, I think, each individual and the space that they're living in. And I think it's really a matter of working with clients to see where they are comfortable. I mean, I've definitely heard in other presentations, we've heard from folks who say people are going in the closet or in the bathroom to do sessions, or providers are in the bathroom doing their telehealth session to hide from their own family or roommates. So I think that people are trying to get very creative right now. And someone just said that some community organizations or libraries may make rooms available for private meetings, like at the library or something. I think that that is a really good point. It will be really interesting to see all the creative ways that people come up with to create those private spaces, because it can be really hard.
Right. If libraries are open where you live, they're certainly not open where we live. So that's another challenge, obviously.
Yeah, or post social distancing, whatever that is.
Someone asked, the person who had asked about referring the person who had engaged in self-harm and making a referral and consent. We talked about that in terms of medical emergency. Then now they're asking how long ago would the self-harm have to have been to be considered a medical emergency? In other words, if it was, months ago as opposed to yesterday, would that make a difference? I think under normal times, yes, but I think under the kind of relaxed definition of a medical emergency, I think that what SAMHSA is saying is if the individual needs substance use disorder care, and they you can't get written consent for the disclosure you want to make, then you can deem that a medical emergency. So I don't think that self-harm is really even relevant to the equation. It's not a prerequisite, certainly.
All right, well, this is Christina again. I think we have neared the end of our questions, and I just want to thank everybody for your participation today. Just want to go through a couple final slides. If you want to get in touch with the Behavioral Health Institute, here are their websites and email. If you'd like to get in touch with us, to sign up for our newsletter about other trainings. And I think that's it. So again, I want to really thank our presenter, our panelists, our colleagues, and just really want to thank everybody for taking the time to learn about this topic. Michael, did you have any parting thoughts before we go?
Thank you. We just wanted to thank everybody for joining us today. Also, we want to let you know that we're here to help. You can reach out to us directly by visiting our website at coephi.org, where you can directly request technical assistance and browse through our resource library, including our available archived webinars. And also, as you mentioned, we'll be sending an evaluation link within the next couple of days. We really would appreciate your honest feedback, and we value your opinion and feedback very much. And again, just thank you to you all for inviting us today to present, and please stay safe and be well.